Norman
My name is
Siegel.
Norman Siegel, civil rights attorney. When we were growing up, we were taught that our Constitution prohibits the government from taking private property in the name of eminent domain, except if it is for public use, such as a public highway. But that turned out to be incorrect. Today, under the concept of eminent domain, the government takes private property and transfers the property to a private entity if it is intended for a public use, purpose, or benefit. Removing blight or enhancing economic development is now also a proper ground for employment of eminent domain. 4 years ago, when the United States Supreme Court in the New London, Connecticut case held that it was constitutional to take property by eminent domain for economic development, it caused a firestorm all across America. Eminent domain became a widely discussed, controversial, and divisive subject. In New York City, the eminent domain controversy, as exhibited by who's here today, and I applaud all of them for coming out and continuing to persevere to address the issue of abuse of eminent domain. It has been played out in the communities of Atlantic Yards in Brooklyn, West Harlem, Manhattan, and Willets Point, Queens. Looking forward, here are a few recommendations for change in New York's eminent domain law that the state, the city, private developers, private property owners, community residents, and elected officials should consider. 1, currently the government can seize private property if an area is blighted, legally defined as, quote, substandard or insanitary, unquote. The law that defines this condition is vague, leaving property owners in a quandary, not knowing what substandard or insanitary means. Listening to the testimony, Senator, when they say they don't have a checklist, that is prima facie vagueness. Because if you don't
What
have
does prima facie mean for those of us that don't have the Esquire with our name?
It means on its face that if they say they don't have any objective standard to determine whether something is a blighted or not, it invites subjectivity, and subjectivity invites discretion. It invites favoritism. And when you hear their testimony that they don't have standards, courts all across this country, both in the federal and the state courts, have struck down schemes that have no objectivity with regard to the criteria to determine when the government decides to do something, especially when there's a fundamental private property right. Vagueness invites subjectivity, as I said. Subjectivity invites selective enforcement. Selective enforcement invites favoritism. All of this is no good. The state legislature, I'll get to that in a second, needs to hold public hearings such as this to elicit public comment so that it can draft better laws clearly spelling out what constitutes blight in the context of the use of eminent domain. The state legislature is guilty itself because in 1976, when it revised the law and created the current eminent domain procedure law, if it wasn't for the state legislature, we would not be here facing the issues that we're facing. Second, one of the factors taken into account in categorizing an area as blighted is the element of what they call utilization. If the government determines that an area is underutilized or that it is not being used up to its, quote, optimal use, it weighs this as a factor in finding blight, sometimes regardless of the character of the community in question. This makes no sense. Moreover, and very important, a private property owner has the inalienable right, in my opinion, to determine the best course of the productivity of her or his property. It is a right that should not be ceded to any government. New York should eliminate the use of eminent domain based exclusively on the use of underutilization. Alternatively, at a minimum, New York should establish uniform rules that provide a basis to determine whether or not property is being utilized. You can't have the government having one methodology in one community using utilization at X percentage, and then in another community using utilization at Y percentage. It just invites the kind of arbitrariness the government is not supposed to engage in. Third, the current process to challenge eminent domain finding is unfair and, in my opinion, unconstitutional. Generally speaking, when a New Yorker goes to court to challenge government action, she or he goes to a trial court. Challenges to the employment of eminent domain follow this procedure in New York until 1976, when the New York State Legislature, and you weren't there, Bill, at that point, they changed the law. Currently, a private property owner must begin the challenge to an eminent domain taking in the appellate court, in the trial court. It appears that New York State is the only state in this nation that employs a scheme that bypasses the trial court. One of the serious weaknesses in the process, as Nick has explained, is the petitioner has no right to discovery or cross-examine the developer's allegations about the specifics of the project, including promises of job creations or generating tax revenue. I would love to be able to do that, especially after the years that I've been at meetings listening to the people from Columbia and ESDC make representations to the community, very often not in a dialogue, but in a monologue. And this aspect of the system needs to be absolutely changed. And finally, the government agencies such as the Empire State Development Corporation that are involved in eminent domain cases should be prohibited from retaining consultants who are simultaneously consultants to the developers who are petitioning, requesting the approval of projects pending before that agency. This practice is very simply a conflict of interest and takes the entire process. And I commend you for your questioning of the ESDC people and Columbia with regard to the role of AKRF in this process. Since the infamous Kelo versus New London Supreme Court decision, 43 states have changed their eminent domain laws to provide greater protections for private property owners from abusive government action. New York has not made any changes. It's time for New York to act. Let me end on a personal note. Sitting here on 125th Street, walking around this building, seeing some of the names and the icons from this community, listening to the people from ESDC speak. On April 4th, 1968, when Martin King was assassinated, our governor, Nelson Rockefeller, a liberal Republican, in the memory and to continue the legacy of Martin, he created the Urban Development Corporation, which now is the Empire State Development Corporation. There were great hopes and great dreams and visions of what UDC was supposed to be. I remember that. As a young kid in Brooklyn who went south in the civil rights movement, met with Dr. King, worked with FCLC for many times. Today, this agency, in the name of Martin Luther King and Nelson Rockefeller, is doing exactly the opposite of what the UDC was supposed to be set up for. UDC was supposed to be set up in the memory of Dr. King in order to clear, quote, slum areas and create affordable housing for low-income people and people of color. Now take a look at what's happening here in West Harlem, 180 degrees opposite. And no one, except you, Senator, is up there and yelling and screaming and speaking and doing the things within the system that we're taught to do to try to bring justice and fairness to the people in this community. And so I commend you for your walking alone. It's not easy to do what you do, especially when the elected officials, from the great Charlie Rangel to the borough president Scott Stringer to local city councilman Bob Jackson, go the other way. But you've always gone the right way and the left way, and in the context of that, we applaud you, and we're here today not only to talk about these issues, but we're here in tribute to you, to give you the courage and support to continue this fight, because when all is said and done, this is a civil rights issue of the 21st century. Thank you.
Thank you very much for the